Good evening, everyone. Once again, a warm welcome to this evening meeting of KMA, which is, I'm not sure of the number, but as we count the speakers, it should be about 110 plus this KMA year. And this is the second of the Memorial Lecture series, that is Dr. Pylee the third of the Memorial Lecture series, that is Dr. Pylee Memorial Session. Before we begin, I would first of all like to express my gratitude to Justice Jayasankaran Nambiar for having graced us today with his presence. Let us start with a silent prayer. Now I would request our chair, Mr. A.K. for the Memorial Lecture series to kindly introduce our speaker and welcome the guest.
Respected Chief Guest of this occasion, Honorable Justice Jayasankaran Nambiar, respected Dr. Lalitha Mathew, the Remembrance, who is doing the Remembrance speech, respected President, Joint Secretary Sri Anil, our dear friends. Every year we used to conduct 3 memorial lectures, remembering 3 giants of the management fraternity of Kochi. Those have been contributed a lot for the development of management in Kochi as well as the industrial development of Kochi. So this is the third of this year. First memorial lectures conducted in memory of the great M.K. Nair. Second was K.T. Chandy Memorial Lecture. Third is M.A. Pylee Memorial Lecture. See, M.A. Pylee, the Moolamattam Varki Pylee, is known as M.A. Pylee, was an authority in constitutional law. He was a scholar, educationalist and management guru. He is also known as the father of management education in Kerala. He has authored so many books and all. Anyway, I am not elaborating about M.A. Pylee. Dr. Lalitha Madam is speaking about him. So when we thought about the memorial lecture in remembrance of M.A. Pylee, what would be the theme we decided? So this is the 75th year of adoption of Constitution for India. So we thought of Constitution as the theme, or Constitutional law as the theme. Then the authority in constitutional law in our locality is nobody other than our Honorable Justice Jayasankaran Nambiar. When our Vice President Sir GSS talked to him, he has readily agreed for this memorial lecture and theme also. So, and moreover, he has come very early to this function. So luckily I myself and other 2 friends were here. Otherwise, yes, he thought that the memorial lecture will be started at 6 o'clock. Somehow some miscommunication, but very early he came, and we have been chatting with the various subjects and all. That's why he came here. And sir, on behalf of Kerala Management Association and on behalf of all gathered here, I am very heartily welcoming you to this function. I'll introduce him later. And remembering M.V. Pylee, Dr. Lalitha Mathew will talk about him because she has translated the book, the autobiography of M.V. Pylee. So that is why she studied about the total biography of M.V. Pylee. So we thought she will be the best person to remember M.V. Pylee and about his contribution. And Dr. Lalitha Mathew is a dynamic and self-driven trainer, and her life is very revolutionary. When I learned her biography at the age of 18, she has become Lalitha Mathew. And though she was born in a Brahmin family, she has become Lalitha Mathew. That was very interesting, and it was in a public domain, not very secret. So, after that, she has, and well, what appreciated her is after she has continued her learning process and achieved doctorate and entered into the field of trainer and mentor and all like that. So, madam, we are happily welcoming you for this session. Our dynamic president, Sri Vibhu Punaran, is was telling about the programs of this KMA year. And one of the members was telling is Vibhu Punaran is now visible only through channels. He is not visible here like that. So, very famous now. So, Vibhu, I am welcoming you for this function. Sri Anil Verma, our Joint Secretary of Kerala Management Association, is always with us for all the function, and today is delivering the vote of thanks. Anil, welcoming you for this function. I am also welcoming the past presidents and MC members and other members to this occasion. Then I have another duty to introduce our Justice. It is very difficult to introduce him because he is serving so many accolades in his career as well as in his life. A renowned judge of High Court of Kerala, who is known for his remarkable judgments in various cases. Sri Nambiar was enrolled as an advocate in 1990 and started practicing with the famous law firm of Ernakulam, Mrs. Menon and Pai. He worked there as senior partner for more than 2 decades. During that time, I think we had some professional interaction with Menon and Pai when he was advocate also. He specialized in constitutional law and taxation, both direct and indirect. In 2011, he was designated as a senior advocate in the Kerala High Court. He has been appointed as additional judge of High Court of Kerala in 2014 and became permanent judge in 2016. He is the son of famous judge. We all know about him, the great Justice A.K. He had completed, Mr. Nambiar has completed his schooling from Lawrence School in Loudale, Tamil Nadu, which is situated in the Nilgiri Hills. Then he graduated in chemistry from SS College, Devara, studied LLB in Ernakulam Law College and passed out with first rank, for which he was awarded the Govinda Menon Memorial Gold Medal. Justice Nambiar has completed Masters of Arts in Law from the University of Oxford in the United Kingdom. While judge, his lordship pursued a doctoral program in constitutional law at O.P. Jindal University and was awarded doctoral degree in the year 2023. In this occasion, who else will get to talk about the constitutional law other than our Justice Nambiar. So I am presenting you a very eminent person who can authoritatively talk about constitutional law when we are remembering another constitutional expert, Dr. Pylee. Thank you. Wish you all the very best.
Thank you, A.K, for that beautiful rendering of both our speakers for today. And now it's time for the presidential address.
Warm good evening to all of you once again, dear KMA members. Our chief guest of the day, Justice Jayasankaran Nambiar, Professor Dr. Lalitha Mathew, Mr. A.C.K. Nair, Mr. Anil Verma, past presidents and MC members of KMA, dear YM members, dear KMA members, and dear students. Once again, I feel proud and privileged to stand before you as I address you in this 49th weekly series of KMA for this KMA year. And as I told you in the beginning, we have completed about 110 speakers for this KMA year till date. Now, A.K. has already told us about the justification of having asked both Dr. Lalitha Mathew and Justice Nambiar to speak to us today on this subject, and Dr. M.V. Pylee. As we all know, Dr. M.V. Pylee was one of the foundations of management in Kerala, or proponents of management education in Kerala. He has done a lot, and I'm sure that Dr. Lalitha will explain to us much more about him. But more than that, today when I was going through the past presidents' list of KMA, I was actually taken aback and feeling a little shaky, because the kind of people who have actually been the presidents of KMA, the stalwarts of KMA, the presidents, I must say that KMA per se, they have brought glory to KMA. So many great people who have adorned the collar of the president, or the seat of the president of KMA. In that sense, all of us must be proud that we are proud members of KMA. And coming to the topic of today, it's constitutional morality, the soul of India's democracy. We all know that definitely India is a democratic republic, and we definitely have a very strong constitution, and we have great judges like Justice Nambiar, who have ensured that we live in a free state, a free country, ensuring freedom for everyone, and I believe that is what the constitution is all about. Freedom of speech, freedom of expression, the freedom to practice the religion that we want to, all this comes into the constitution. But then there are exceptions here and there, or rather deviations, when people take the law into their own hands. And Miss Universe finalist Miss Nafisa Joseph, in the year 1997, she was asked this question in the US when she went for the final interview, final round. What was the biggest injustice in this world? And her snap answer, which shook everyone, was to bring a child into this world and not even be able to provide peace for him or her. I think that stands good even for today. But the sad part of this particular lady, Nafisa Joseph, having risen to that level, is that she finally, at the age of 26, she committed suicide. And for what reason? Because her fiancé ditched her, or rather, she came to know on a later stage that the man that she was supposed to be married to had already married someone and was the husband of someone, and he had not officially divorced her. So this lady in all anguish committed suicide. That's how the story goes. And her parents filed a case against this man, but it went no avail. And then I was also thinking about this movie called Abraham in Malayalam, where Mammootty is the star police officer, and he takes, I would say, the law into his hands, although he is a policeman. And I believe that is based on certain incidents. This whole story is built around certain incidents where the police officer does not wait for the criminal, people who rape girls, people who commit drugs and all that. He doesn't wait for anyone. He just brings them in, and then he finds out some reason or the other, and then he shoots them dead. So he doesn't give them to the law at all. So he takes the law into his own hands. Now, we know for sure who is right, who is wrong, we cannot say. I think justice will be able to throw more light on such kind of things to us. So I definitely do not want to keep you waiting to hear from such a learned speaker of today, a man who's given Kerala so many valid judgments with empathy. And I think he is the most right person to address us today on the constitutional morality. With this, let me welcome you, sir, to this evening meeting. Thank you. And now I would request Professor Dr. Lalitha Mathew to kindly give her remembrance speech on Dr. M.B. Pylee.
Respected Justice Nambiar sir, and top-notch of this year's KMA on the stage, ladies and gentlemen. If ever words of highest praise have been showered on a scholar, the mighty lines of Christopher Marlowe stand testimony for Dr. Faustus when he said, "Fruitful plots of scholarism he graced, that scholarism in turn graced him with a doctor's degree." And that was our Pylee sir. Our dear Pylee sir, Padma Bhushan, Professor Emeritus, Dr. M. Pylee. Pylee sir, the legend, who rather than being acknowledged as a great scholar, can be considered as such an intellectual giant that scholarism personified stands honored by being the acquired asset of this erudite personality. That is, what I am trying to say is, scholarism found it a grace to be graced by our Pylee sir. Those are the lines of Marlowe I was quoting. And scholarism personified adorns him, Dr. Pylee sir, in turn, with all the laurels a man can amass in the longevity of almost a century. This is a remembrance speech, but all the details about Pylee sir, his qualifications, or where he went, what he did to the academic field and to society, the societal contributions that he has done, everything is known by all management students and management practitioners. He is definitely the son of Mother India in many, many ways, because, as we all know, he brought management education. Kerala Management Association or All India Management Association, management associations by themselves. How did they become? so big because management came as a criterion, as a study, as a teacher and the taught, they thought about management. Management as a phenomenon came into being. And Pylee sir brought that. And I'm not going too much into that because it is already known. Moreover, Mr. Nayan had told me that everybody knows everything about Pylee sir, and in the given 10 minutes, admonishing, given 10 minutes, you have to say more of your personal touch with sir. Well, that's definitely justifiable. Pylee sir was a man of very simple tastes. He never demanded anything from anybody. In fact, he helped others in need in so many ways that there is simply no time to tell what all he has done. At least the little bit I know must be only a very small portion of what all help he has done for others. People who are needy, people who are, who come to him for some help. Even if it is not his field, even if it doesn't come under his radar, he always used to go out of the way and help people. And then, little things I remember about him. First, I'll tell you about his breakfast habits. He used to start the day with the bitterest of juices, pavikya juice. And he drank it like old vintage wine. He enjoyed it. That is the thing. And then pieces of pavikya put on the plate for breakfast with a fork and knife and all. Like a westernized person, he used to have happily as his breakfast. Many days they used to have one or two more people extra for breakfast. And Auntie used to be prepared for this, but he always used to say, don't make anything extra, just spread the table as it is. And coming to this point, I have to tell about his wife because she was like a shadow. She was with him, she was part of it. And she was the matriarch of the management of the house. She never bothered him about everything. And one thing I would like to express is that she never ever interfered with his official life, his policies, his ideologies, what he did, and Pylee sir got 100% personal space for him to operate his activities, and that is a union, a compatibility that we have not seen in many couples, And Elsie auntie, when she passed away in her age of 78, she, Mama Bhagavad, left side, right side, everything he lost. But Pylee sir was a man of iron will. Nothing could ever crush him. Life went along for him. When they both, in their younger days, when they went to Pennsylvania, for him to work at the Pennsylvania University, they left 3 small children behind. Varghese, Merrily, and the little one Anu was only 4 years at that time. But they were all kept in a boarding, and Anu tells me she even developed a fever because her parents, Appajan and Amma, were going away. And but then Pylee sir thought, to get a greater thing in life, you need to sacrifice certain things, certain personal things. He taught me a lot of things, ladies and gentlemen. First of all, I am honored that I am given this chance of giving this memorial speech about my Pylee sir. Let me thank KMA for that. And he taught me, see, whether it is grief or rejoicing, whether it is weeping or dancing, whether it is happy or hurting inside, one has to control emotions. There's no question of giving out what you really feel and make a fool of yourself in public. He gave me real inspiration for a new life, new hope. And every day was a rebooting day for me because of his advice. Pylee sir gave me the power of discernment. And sometimes when he talks about like sell through the dealer, sell to the leader and all, the idiotic look, I used to sit there. It was going above board. I didn't understand anything. Then he used to say, well, this is not your field. You better sit with your language and literature and music and fine arts. Anyway, don't worry. He was a very, very father figure for me, the kind of father figure for me. And when he was hospitalized, his daughter Anu called me one day and he said, Apchan is in the hospital, he wants to see you. Second or third hospitalization, this was the final. And I just took the car and went and saw him. I didn't know it was his deathbed because Pylee sir always used to go to hospitals and come back happily with no broken spirit, nothing, and consoling her, say, why are you worrying? So I'm back here, no. That was the kind of thing. But this time I don't know. He held my hands. I'm very emotional now, in his weak old hands, and he said, പിടിവിടരുത്, ജീവിതത്തിനുള്ള ഗ്രിപ്പ് ഒരിക്കലും വിടരുത്, ഇതുപോലെ തന്നെ മുമ്പോട്ട് പോകണം. ആ കണ്ണ് ചീരക്കുത്തുപോലെ ഷാർപ്പ് ആൻഡ് അലേർട്ടായിരുന്നു അപ്പോഴും. And the next day he passed away. And what he said to his daughter was, Anu, you call her Lalitha. She's a good person. She's a very good human being. More than I want to see her, I know she won't be able to bear it if she comes to know that I'm dead. See, even there, that's part of selflessness I could see, actually. And those words are really memorable for me till I die. I feel that Pylee sir is here among us now. And quoting Matthew Arnold in Sorrow and Rustam, these lines I feel Pylee sir is telling us now. Wherever I go, whatever realms I see, my heart, always untraveled, fondly turns to thee. That thee happens to be us. Pylee sir can never leave us. He has really not gone. And I think Pylee sir was not a legend. Pylee sir was not a legend. He is a legend. He is a legend, and he shall be a legend until, as long as teaching and learning of management studies goes on.
Thank you, Dr. Lalitha, for speaking from your heart on this great stalwart, Dr. M.V. Pylee. Now, I would request our chief guest of the day, Justice Nambiar, to kindly address us with his keynote address.
Good evening, all. First up, thank you, ACK, for those warm words of introduction. The same goes to Mr. Vibhu. Thanks also to Dr. Lalitha for those really heartwarming words of Dr. Professor Pylee. I just need to clarify at the outset, when ACK mentioned that I was in a rush to come here, I had no such idea. I did actually run from my court because the message that Algiers had sent me said that I must be here by 5:30 for the high tea, and 6 o'clock on the dot we would start the program. And although they cleverly changed the card and showed me something, they forgot to change this. Going by this program sheet on the table, we should be having dinner by now. The vote of thanks was at 6:30. But I was keenly listening to Dr. Lalitha and what she had to say about Professor Pylee. I did not know the man. I've heard a lot about him. I know he was the president of your organization sometime in the 70s. But I do deem it matter of great pride and privilege to be called upon to deliver a lecture that is held in the name of this distinguished jurist of our soil, a Padma Bhushan awardee in 2006. His contributions in the field of law, in the field of constitutional law, and generally to jurisprudence in our country has been immense. And therefore I thought it would be befitting when Algiers called me, and he said, would you mind talking to our audience? And I said, it must be on a subject of constitutional law. And therefore here I am. trying to speak a little about constitutional morality and the soul of India's democracy. And we all think we know what the Constitution of India is. You probably conjures up an image of a book like this. But let me tell you that it is not just a book. In fact, when we talk about a constitution, generally, we are talking about an idea, an ideal, and a concept. And what exactly does this concept convey? You must remember that when we talk about a constitution, we are talking about broadly about principles and rules that speak about the distribution and the exercise of governing power in any state. Largely, this is what a constitution means. Now, it can take many forms. It can take the form of a written constitution like we have here. But we do talk about constitutions in countries which don't have this book, like England, for example. So you have written constitutions, you have unwritten constitutions. Now that sounds like a contradiction in terms if you have this image of a book as a constitution, because you don't see one. So I'll come to that distinction in a bit. But broadly, this is the idea. It's a set of rules and principles that dictate how the governing power is distributed among various bodies and how it is exercised. Now, as I said, we have a wonderful constitution. It was put together after a great deal of effort. It took about 2 years, 11 months, 17 days to be exact, to draft this constitution between 1946 and 1949. And on 26th of November 1949, we gave to ourselves this constitution. At the time that it was adopted, it had a preamble, 395 articles, 22 arranged in 22 parts and 12 schedules. It was then, and I venture to think that it is still one of the lengthiest constitutions in the modern world. And you compare it with some of the older constitutions like the US Constitution, it is all of 7 articles. We have 395. And when it was adopted, the general longevity of constitutions worldwide was about 15 to 16 years. The American Constitution was, of course, the exception. We're talking about modern constitutions after the World Wars and in 1948, after the UN Declaration of Human Rights. So, generally, constitutions of that time did not last more than 15 to 16 years. So, the famous statesman, the English statesman, Ivor Jennings, he criticized the Constitution of India. He said it was too long, it was too rigid, and it was too prolix. Prolix is when you use too many words to convey a particular idea. So he said that was what our Constitution was, and he gave it an average of 15 years survival. Well, we proved him wrong. It's been 75 years now since the adoption of the Constitution. We're still going strong. We've had about 103 amendments to it, but that's no big deal. The Constitution still holds and governs all of us. But let's talk about Ivor Jennings for a second. He drafted a constitution for Sri Lanka, Ceylon as it was then, and that didn't make it beyond 6 years. So we had the last laugh when it came to the Constitution's longevity. The second thing about the Constitution which I want you to remember at the outset is that Ivor Jennings also said that this was a lawyer's paradise, because it was so lengthy and it had so much, as he said, too prolix. He said this is going to be a lawyer's paradise, because this he thought was a legal document. It is not. Probably our Constitution's greatest biographer, a gentleman called Granville Austin, he's written a treatise on the Constitution of India. It's called the Indian Constitution, a cornerstone of a nation. And he begins that book with one very significant statement. He says the Constitution of India is first and foremost a social document. It's not a legal document. So if any of you have been harboring such doubts and finding yourself an excuse not to read the Constitution, this might just be the tipping point. You need to read the Constitution, and I'll tell you why in what follows. I wanted to start with an introduction about the Constitution, the scheme, and what precepts and ideals it has, because it's pointless talking about constitutional morality if you don't know what on earth the Constitution contains. Because morality, as we all know, general popular morality, when we speak about popular morality, we are talking about codes of conduct, good and bad conduct. When you put that or set it against the backdrop of a constitution, you need to know what is good or bad under the constitution. What does the constitution tell us about how to live in society? So you need to have some idea about that. And there's no better place for those who don't have time, there's no better place to look for it than just the preamble of the Constitution. It's a very short rendition. It's a short paragraph, but it was a paragraph that was drafted at the very end of those discussions that happened in the Constituent Assembly debates. After they had discussed almost everything for 2 years, 11 months and 17 days, then came the putting together like a précis, the fundamental principles and ideals that the Constitution contained in the preamble. The preamble, unlike other constitutions like the US Constitution, is a part of the Constitution. Now you would think that that's a strange thing because you always expect it to be part of the Constitution. But in the US, the preamble does not form part of the Constitution. They say the preamble walks in front of the Constitution. So it gives you some idea of what is contained in it, but it's not actually part of the Constitution. But in India, the preamble is seen by the judiciary, declared by the judiciary as forming part of the Constitution. So what does the preamble say? How many of you know the preamble, by the way? Thank you, that's what I expected. Keeps us in business. It begins with those words, "We the people of India, having solemnly resolved to constitute our nation as a sovereign, socialist, secular, democratic republic, and to assure to all its citizens various things." What are they? Justice, social, political, economic, equality of status and opportunity, liberty of thought, expression, belief, faith, worship, fraternity, assuring the dignity of the individual and the unity and integrity of the nation, and we give to ourselves this Constitution. We enact, adopt, and give to ourselves this Constitution on the 26th day of November 1949. These are words pregnant with meaning, and it's not something that you just read like a novel and go home. You need to reflect on it. You need to introspect on it, and that's why, for most lectures that I take on constitutional law for judicial officers, law students, I tell them don't look beyond the preamble. Just look at the preamble and start concentrating on each word, and then you get some idea of what the Constitution contains. But what exactly is a preamble in the first place? It does three things. The job of a preamble is basically to do three things. First, it tells you the source of the Constitution. We, the people of India, give to ourselves the Constitution. So it's entirely a making of we, the people of India, the citizens of this country. Secondly, it tells you what are the principles, what are the ideals, what are the aspirations that we have as a new fledgling nation. We just wrested control from the British. We've got freedom. Where do we see ourselves about 5, 10 years, 50 years from now? So it gives you the principles by which we have decided to govern ourselves. So that's the second. It declares the rights, the freedoms that we have. And lastly, it is also contains the enacting clause. Give to ourselves. Enact, adopt, and give to ourselves the Constitution. So you have those three fundamental roles that are discharged by the preamble. Now let's just look at that a little more in detail. We the people of India, and then you have those words, sovereign democratic republic. I deliberately missed out the secular and socialist because that wasn't there when the constitution initially came. In 1950 we had only this, sovereign democratic republic. The other two came along with the 42nd Amendment in 1976. But when we say we the people of India constitute ourselves into a sovereign democratic republic, there are a lot of things that come in, ideas that come in. First and foremost, you must remember that in primitive societies, how would you expect a government or a governance of the people in primitive societies? You'd have people with different talents, unique talents. You'd have some people who are very strong, who would be the ones who would, hunt and get food. There would be others who would fish. They would have a specialty skill for that. There would be others who would look after the homes. There would be others who were craftsmen. So each of them is important to form the society, but not one of them cannot do it alone. And you can't be individual silos. You can't live independent lives. So you band together, and then you decide to have one person as your leader. He sort of coordinates everything. Pretty much the same as what you're doing in this hall with your leaders here. So you pick one of them to manage everything for and on your behalf. It is pretty much the same when you had societies with a monarch, a king. The king would normally be the person who was the strongest of the lot because he would defend the rest of them from enemies, both from outside as well as inside. But that concept of a monarch soon had to give way because primitive societies were small, and this worked when you had a small bunch of people trying to live together. The minute the societies got bigger and the distance between the people who were ruling and the people who were ruled got larger, you needed some other form of governance. There was also the problem that a monarch would invariably have a lineal descendant who need not have the same talent as the monarch. So maybe a tough monarch would have a weak son, and he would inherit and become the monarch just because of the hierarchy and the descendancy. But he would not command the respect of the people. So monarchy had all sorts of problems. And therefore we had Western philosophers coming up with this idea of a state, which is completely different from what a monarchy is. Now, the most simple imagination of a state came from a Western philosopher called Thomas Hobbes. And he came up with this idea of what he called a Leviathan. Now, what is a Leviathan? If you Google Leviathan, gone are the days when you look up Leviathan in the dictionary. Today it's all Google. ChatGPT, DeepSeek. So if you look up Leviathan, you would find it return a definition of some kind of a sea monster. But for our purposes, I would request you to imagine what we're more familiar with, a cloud. Right? And a cloud is what a Leviathan is. Imagine a cloud which draws its power from the concessions that we as individuals in society give it. So we all have as individuals we have powers, we have liberties, we have strengths. We mortgage or we give a little bit of this to the cloud so that the cloud becomes a very powerful person who can then rule over us. This was the concept of state as understood by the later thinkers in Western philosophy. Because till then, the last monarch, famous monarch, was Louis XIV of France. And he famously said, "L'État c'est moi," which basically means I am the state is me. And that was, that was the height of arrogance. And people soon realized that this was not going to be. And we had a concept of a state come in, and the state has got either trifurcated or quadrificated. You'd have different organs combining together to form a state. So this whole idea of a state, a republic, etc. comes in from that transition from what a concept of a society and a ruler was to the concept of a state. From this conception comes the idea that we can be ruled not by men or women, we can be ruled by a law. And the advantage of that, and this is what we call rule of law. This is something that law students, professors, jurists, judges, everybody struggles with. Fortunately, nobody asks those questions, even in law schools. We talk about rule of law. I mean, you must have heard this phrase pop up in the newspapers, in the journals, in books, everywhere. Nobody's ever had the courage to ask anybody, define rule of law, then you're lost. You can't define rule of law. But in its essence, what it says is that, there is nobody above the law and everybody is equal before the law. So you get that concept. And that is why we say when we have a rule of law, that's the ultimate, that's the ceiling. And from there comes the laws, and those laws, as far as implementation of those laws are concerned, everybody is equal before the law. So you have this concept of rule of law in the context of a constitution which you have given to yourself. You have decided that the constitution will govern every action of yours. There is nobody above the constitution. So even your monarch, your ruler, is subject to the law, subject to the constitution. So this idea of constitutionality, constitutionalism, is what we are governed by even in our country, thanks to this wonderful document. The second feature of our constitution is the separation of powers. Now, as I mentioned earlier, you do have the state being comprised of three different branches: the legislature, executive, judiciary. You all know that. When we talk about separation of powers, unlike what happens in the United States, for example, where you have a legislature which is separate in all respects from the executive, you have the president, you have Trump, and you have the Congress, and then you have the US Supreme Court. These are three silos, each functions on their own, and there is a strict separation. This was something that the French philosopher Montesquieu talked about. He said there must be a strict separation of powers. You can't have one meddling with the other. But in India, we don't have a strict separation of powers. We have something called a separation of powers qualified by checks and balances. What this means is nothing but you have a functional separation between the different organizations. So they each function within the particular areas where they have expertise. But the actions of each of these are checked by the other. So you have a control of sorts. So nobody is an absolute, authority in anything. And that's the essence of constitutionalism, where nobody is an authority, nobody is absolute, nobody has got absolute power of any form. So we have that concept of separation of powers. Socialist. Now we're coming to the 42nd Amendment, 26 years later. We have socialist and secular inserted into the Constitution. What do you mean by socialist? What is the general idea of socialism? You would think that it is the entire resources of the state is owned by the state, and they give you, a little bit of it as and when they feel like. But that's not the socialism that we are talking about. Our socialism only limits itself to controlling the distribution of resources. And we are only concerned, private ownership is encouraged in our country. You all know that. Socialism, therefore, is only a method of ensuring that the natural resources, the material resources of our country are not concentrated in a few. So this is what it essentially says. And that's the beauty of this document, because if you've all heard of those 2G cases, spectrum cases. The Supreme Court writes judgments, and I must say that some of these judgments are becoming more and more difficult to read, because There was a time when in the 1970s we had the longest judgment rendered by the Supreme Court was the Keshwananda Bharati, which gave us something called the basic structure doctrine. That ran into something like 1,000 pages. It was one volume. No law student does. Any law students here? There's no law students here? Okay. No law student has ever read it, cover to cover. No judges read it, cover to cover. I had to read it because my dissertation, my thesis was on the basic structure doctrine, so I had to read it 3 times. Not easy. So but that in 1970s that was just a one-off judgment. Today you have judgments running into pages and pages. It's literature, it's prose, it's everything. The Aadhaar judgment runs into 1,300 pages. The Shabarimala judgment runs into 890 some odd pages. The I think the Spectrum, 2G Spectrum case ran into 600 pages. Essentially what 2G Spectrum case decided by the Supreme Court said was that you must have an equitable distribution of the material resources by a system of auctioning, so that everybody had an equal opportunity of getting, getting a chance at bidding for a spectrum. This is what it said, and in the Constitution, the entire gist of that 680-page judgment is in one sentence. It says, the state shall ensure that the material resources of our country are so distributed as not to prevent the concentration of wealth in any particular person. 1950, this was possible just by legislators, just by our representatives sitting together and applying their minds before they made law. Today what happens is you have cut and paste legislation, interpretation of that cut and paste legislation goes into another 1,000 pages, and we're still in a search now as to what is illegal. So all of that gets, the whole idea behind what is the essence of the Constitution gets lost in this rhetoric, which is why people are today struggling and they run away when they talk about constitutionalism and constitution. Secular, briefly stated, it is separation of the state and religion. So the idea that you shall not in this country favor any particular religion when it comes to matters of state. So no active promotion of any religion, tolerance to all religions, protection of minority religious practices from majority override. Essence of democracy. Right? Justice. You have social, economic and political. Now in 1950 when we got our constitution, political justice was pretty easily obtained. All you had to do was ensure that everybody had an equal right to participate in governance. And how did you do that? Universal and suffrage. Everybody was given the right to vote. So almost overnight, we gave to ourselves political justice. Social justice, not immediately, because when we got independence in 1947, what happened on 14th, the society that was there on 14th of August pretty much remained the same on 15th and 16th of August and for many years later. So you couldn't get this transformation of a society from the colonial society that we had to an egalitarian society that we dreamt of. So that progress was a little slower. But what was most slow and moved at virtually a snail pace was economic justice. Social justice we've been talking about and we've achieved considerable milestones, but economic justice, no. The divide between the rich and the poor in this country is still very high. 10% of the people, 10% of the population controls more than 80% of the national wealth. And that's nothing, it's not equal, it's not equality at all. It's a very depressing sort of situation. Then you have the concept of liberty. Liberty is basically freedoms that a person is supposed to have so that you can enjoy the fundamental rights that you've been granted. So you have liberty of thought, expression, belief, faith, worship. Equality of status and opportunity. Status basically to level the playing field for caste discrimination, sex discrimination, gender discrimination, etc. and economic discrimination. Opportunity, everybody must get equal opportunities for public services. So you have your reservations, affirmative action, etc. So if you look at the whole scheme, you're looking at something that is built or geared towards an egalitarian society with a welfare state at its helm to ensure that all goes well. Fraternity. These are concepts that have been gaining traction in recent years. Fraternity, the words used in the Constitution, the preamble, are fraternity assuring the dignity of the individual and unity and integrity of the nation. Now, dignity of an individual is not a concept that we were used to. It was just granted, taken for granted. But very soon in society, we started seeing the waves of discontent. We suddenly started opening our eyes to newer forms of relationships, newer forms of orientation. It began with people, the homosexuals, the lesbians. You have transsexuals, transvestites. These are all new, but the progress in society, the development in society, and the kind of tolerance that the majority have exhibited to these sets of persons has been abysmally bad. And therefore, it is not until 2017, although the Supreme Court, through various judgments, has been trying to read in these concepts. Because if you look into it, you must understand that it's not, while the legislature is the one who makes the laws, which have to adhere or which have to conform to the Constitution. The judiciary is the one which interprets those laws, and sometimes what the legislature does not say, the judiciary supplements through a process of interpretation. So we are saying that when the legislature uses a particular word, it actually means this, which is why you get, when the legislature says a person means all of these persons. So everybody, individual with whatever color, hue, and sexual orientation is also a person, and a natural person at that. So you have these methods of interpretation which try to bring in the constitutional ideas into a legislation which does not expressly mention. And this is the kind of activism that the judiciary has been doing to try and bring more and more people into the mainstream to be a more inclusive kind of society. Now, the LGBTQIA++, and now you have something called 2S also. How many of you know what 2S is? That's what I thought. 2S stands for two spirits. So you have the lesbian, gay, bisexual, LGBTQ, Q, queer, intersexual, asexual, ++ stands for more categories coming in. 2S now means two spirits, which basically translates into, it gets more and more complicated. If you're sitting here listening to me and wondering, what on earth is going on, imagine my plight when I sit in court and I'm trying to solve actual disputes which involve this, right? Two spirits is basically when a person thinks that he or she is in spirit something else. Now, I could be in spirit a cat or an owl. That is my spirit. And you're supposed to be happy with that, by the way. So, because otherwise it's intolerable and it's not constitutionally moral. So these are the kind of problems that we are going to be dealing with. And therefore, the point I'm trying to make here is, it's important that you know that our Constitution recognizes all this. And you can't shy away, you cannot feign ignorance about the constitutional ideals, because the constitutional words are not static. The written text is not static. The meanings keep changing in society. And that's why we say that there is an inherent scheme of incremental empowerment of the citizenry in the Constitution. what do you mean incremental empowerment? As I said, at the time when we got independence, at the time when we gave to ourselves the Constitution in 1950, there were certain things that we were assured of in society. You have these wonderful concepts: fundamental right to equality, you have fundamental right to life, you have the right to property, etc. But over the years, the meaning that has been given to these words, whether it is property, for example, meant nothing more than actual land and your homesteads and things that you actually saw. But today, the definition of property is gone, is expanded to embrace corporeal, incorporeal, tangible, intangible. You're talking about intellectual property, things that you don't see, you infer, data, right? So as we move in society, as we develop as a society, these concepts also change, and we have to use the written text to accommodate all these ideas that are emerging. So as society changes, the interpretation of the Constitution has also got to change to keep in sync with changes in society. And that's the task that the judiciary does. Unless, of course, the Parliament steps in to amend the Constitution. So, this exercise of keeping up to date with the constitutional principles is something, as I said, we are talking about, we are not talking about a legal document, we are talking about a social document. There's nothing in the Constitution which says that the judiciary is the sole guardian or the interpreter of the Constitution. No. Your village officer, you as a citizen, your village officer, Tahsildar, your district collector, your corporation clerk, all of them are supposed to understand the meaning. Good luck trying to get them to understand the meaning, but they are supposed to do it. It's not an excuse to say that these are constitutional matters, give it to the lawyers. That was not the idea. In fact, that was the fear that this would become a lawyer's document. The idea was for it not to become a lawyer's document. So with these ideas that are there, these concepts, these ideals in the Constitution, what exactly do you mean by constitutional morality? Now, in a country where you don't have a written constitution, a constitution, as I said, is broadly the rules and principles which talk about the distribution of governing power and the exercise of governing power. In countries like England, which don't have a written constitution, you have normal acts of parliament which talk about how a particular law is to be made. There are statutes that define how the law is to be made. So you will have representatives voting on a particular point. How many of them should come together? It is the Queen in Parliament, or now the King in Parliament. So those procedures are detailed in certain acts of Parliament. So you have those. But apart from these acts of Parliament, which clearly say that there are procedures, there are substantive requirements, you also have something called conventions, customs, practices. These are not written down anywhere. So how does one know about this? It's only through what you've been following. It's a custom, it's a practice. So those customs and practices were what was known as constitutional morality. Just as you have code of conducts, you have practices, customs, rituals which form a particular code, and that was called constitutional morality. In India, since Ambedkar famously said, when we decided to have democracy as our governing route, he said, unlike in Britain, you can't just impose or infuse the idea of democracy to Indian society. Because if you do that, democracy would only be a top dressing on Indian soil. This is the words he used. He said that democracy would be top dressing on Indian soil. Which means we were not aware of the conventions and the customs and the practices that normally inform a democratic government. So how do we get the people of India to understand, study all this and imbibe this? You can do it only by putting it in the Constitution. You have to put it in writing. So that's why our Constitution became too long, too rigid and too prolix. Because we had to put all these things, the procedure. If you open the Constitution, You will see the relationship between the legislature and the executive and judiciary. You will see the procedure for making bills, money bills. Everything is there in the Constitution. And that is because we needed to have a complete guidebook on how to govern. And so in India, when we speak about constitutional morality, we are not looking at conventions, customs, etc. We are looking at simply adherence to the principles in the Constitution. This is constitutional morality in a nutshell. So how far have we gone? What have we done? How are we living it today? Does any of you think that we are abiding by our constitutional morality when we come to living our daily lives? Can anybody keep his or her hand on the heart and say that I have been a good citizen, I have lived life according to the Constitution today? Every time you pay that 10 or 100 rupee or 1000 rupee bribe to the man in the corporation, you just kiss goodbye to the concept of constitutional morality. Right? Every time you don't help somebody in need, every time you don't show compassion, you've not abided by the concept of constitutional morality, because you have something called fundamental duties in the Constitution. It was not there in 1950, which has always amazed me. We are a country which was, the legal system of our country, the ancient Indian legal system, was founded on the concept of what we call dharma, loosely translates as duty. The question that we asked in society then was, what do I do for the others in society? The British came in, 200 years of British rule, changed all that. Now you're asking the wrong question. What do I get from society? You're talking about rights. The question with that, a rights-based regime, is if you survive 75 years asking that question, it makes you a very selfish society. And that's what happened to us. A country and a nation which was founded on this ancient concept of dharma. When we got our independence and we gave to ourselves a constitution, we didn't have a chapter on fundamental duties. We had a chapter on fundamental rights. Don't you think that's strange? We got a chapter on fundamental duties 26 years later. And even now the position has not changed. If you look at the chapter on fundamental duties, it's a separate chapter. It's worth reading it because it contains many things that should inform ideal conduct in society, but it's all brushed aside. As part of the legal services authority's contributions to society, I had actually got a booklet on fundamental duties circulated to almost every school in our state. I don't know what's happening, but I hope people are reading it as they should read the Constitution. Now, judicial interpretation of constitutional morality. I'll just take 3 cases for a reference because there's a lot of it. But 3 cases serve to highlight some very interesting things that happen in our society. And it shows you how the judiciary has, sort of rested or tried to interpret its way out of a situation where we found that the Constitution was not being implemented or being taken seriously in society. The first, of course, is the famous Jayasankaran Nambiar, the one I said, the long judgment which nobody's read. Now, what happened in that was there was a serious tussle between the executive and the judiciary when it came to the question of amending the Constitution. Now, the Constitution, there's a particular article in the Constitution which says that any provision of the Constitution can be amended. There was another provision in the Constitution, especially the one with fundamental rights, with Article 13, which says that the state shall not make any law which takes away or abridges any of the rights conferred by this part, and that's fundamental rights. Now, why did we have such a thing? It's not very difficult to gather, because the fundamental rights chapter was modeled on the Universal Declaration of Human Rights, which is what we had in 1948. The UN Declaration of Human Rights was there. We almost bodily lifted the entire concept into and placed it in our Constitution, which we gave to ourselves in 1950. So when we were drafting the Constitution, we had these ideas. So if you look at the part 3, which talks about fundamental rights, it's almost entirely dealing with basic human rights: your right to life, your right to equality, your right to against discrimination, etc. So we had those concepts here. Article 13 said, the state shall not make any law that takes away or abridges. Look at the words used. Takes away means you are taking it away completely. You can't take that. Abridges, lessen the scope. You can enlarge it. There's no problem, because you're only widening the concept to accommodate newer areas. So this concept of not taking away, not abridging the fundamental rights is there, written in black and white in our constitution. Now here's where the interesting part happens. The famous Indira Gandhi years, and the executive was very strong. It started making encroachments into the rights of citizens. You had the emergency. Almost overnight there was a declaration that no person could move the Supreme Court or the other high courts for alleging violation of their fundamental rights. And more importantly, the right to life. It was mayhem. Suddenly you have a law which says that you can't approach the Supreme Court or a high court saying that your right to life and personal liberty has been taken away. Now, Article 13 says very clearly that none of these things, no state can make a law. The control orders that were passed by the government then would come within the definition of law. But you couldn't go to court to challenge it because you're saying that it is a violation of your fundamental right. And you have the famous case of ADM Jabalpur, which the Supreme Court basically said we're helpless. There's only one judge who's gone down in history as Jayasankaran Nambiar, the uncle of the present CJI. He was the lone figure, and he did it very eloquently for those who know to play with words. He said the right to life is basically a human right, and it was not a right that was conferred by the Constitution. Right? The human rights are not given by the Constitution, which is why if you look at the wordings immediately after the World War, the UN Declaration of Human Rights, the word used is UN Declaration of Human Rights. It's not a UN conferment of human rights. It's a declaration. And what is a declaration? You always declare something that is already pre-existing. So he said, when Article 21 is suspended, when you have lost the right under Article 21, you can still approach a court if what is taken away is not something that was conferred by the Constitution. I always have a right to life, and I can always agitate that in court. But he was a lone figure, so it didn't carry. Of course, that was reversed much later, formally reversed, but we tided over that because the Parliament started amending our laws. Now we needed to protect this. Initially, 3 judgments of the Supreme Court was basically had committed the mistake, if you ask me, of accommodating a government. See, what happened was the first 2 judgments came in the context of a right to property. Soon after we got our constitution, we had a serious problem because the government, after getting independence, the first government was embarking upon a socialist reform agenda. So you needed to take land from the persons who had it and distribute it among the landless. Agrarian reforms. Now the first parliament for India was actually doubling. They would sit in the mornings as a constituent assembly and in the afternoons they would sit as the parliament. So on the one hand they were drafting all these grandiose norms of fundamental right to property, and in the afternoon they were wondering how on earth are we going to get this property. Right? In 1950 you gave yourself the constitution and you saw that there was this Article 31 which said that every citizen has got a fundamental right to property. And it meant that you could not take property from anybody unless you compensated them. And it was just compensation. So what is just compensation? Something fair, something which will be a recompense for what you're taking from them, market value, or something close to it. But here was the catch. The government wanted the land, but they didn't have the money to pay for it. Now, how do you get over this? They ran to the Supreme Court. They said, Nehru, there's a wonderful book called 16 Stormy Days by a person called Tripur Daman Singh. And he basically encapsulates the entire exasperation that the Nehru government was facing in trying to amend the constitution, because they couldn't amend it. Because if you amend it, Article 13 would come in and say that the state cannot make a law which takes away or abridges any of the fundamental rights. And Article 31 is the fundamental right to property. How do you get over it? They go to the Supreme Court, and Supreme Court intellectuals, intelligent people, they said, this provision in the Constitution which says that state shall not make a law which takes away fundamental rights refers to an ordinary law made by Parliament, not a law made by the Parliament in exercise of what they call a constituent power. A constituent power is a power that brings into existence a constitution. A constituted power is a power that is conferred by the Constitution and exercises a power under the Constitution. So you're talking about the very creative power when you're talking about constituent power. And they said, this clause which says that you cannot abridge or take away refers to law made by a constituted body, not a constituent body. So it is basically semantics. But they saved the day, because those amendments then carried, because it was an exercise of a constituent power. So the fundamental right of property was diluted initially. Much later, when the Janata government came, they took it off in its entirety and put it as a constitutional right outside of the chapter on fundamental rights. This happened again for another amendment, the fourth amendment. But after that came Indira Gandhi. And now they found themselves in a pickle because they had permitted an amendment of these fundamental rights. And now suddenly Indira Gandhi was talking about taking away or abridging the fundamental right to life and personal liberty itself. How do you say no? Because you've got precedents. Then comes the third judgment, which is Golaknath, where 11 judges of the Supreme Court split on a 6-5 majority and came to the conclusion that, hang on, we've got it all wrong all the way. Let's just read what the Constitution is saying. The Constitution says that no law can be made, and when you amend the Constitution, you're doing it by a normal lawmaking process. An Amendment Act is also an act of Parliament, so it is a law. Status quo restored, status quo ante restored. So we came back, all was well. Indira Gandhi didn't stop. Then came the next amendment. She again amended the Constitution. Now, and you must understand there are judges in the Supreme Court which are also politically influenced. So the ratio is now changing. From a 6-5 majority, the next case which doubted the correctness of this judgment went before what we call the Keshavananda case. That is decided by 13 judges of the Supreme Court. And the 13 judges, you must remember, at that time there were only 13 judges in the Supreme Court. So you had the largest bench of the Supreme Court till date, 13 judges. And they came up with they found themselves in a very difficult situation because they had to get over the 11 judges. They got over it and they said, you can amend any provision under the Constitution, including the fundamental rights. They read in Article 368, the amending power. They said you can amend any provision of the Constitution, no bar. But you cannot, this is where constitutional morality comes in, your adherence to the principles of the Constitution. Do not amend the Constitution out of its existence. Do not change the identity of the Constitution. So they said, while you can amend any provision of the Constitution, you cannot have an amendment which destroys the basic structure or the basic features of the Constitution. So, essentially they were saying what the earlier gentleman was saying, but they said it in better words. So, they said, you can amend the Constitution, but some of the fundamental rights are basic features of the Constitution without which you cannot have or even dream of an existence of a Constitution. You can't touch those. So this is where we stand. If you ask, and this is what my thesis was on, it was efficacious to control a powerful executive then. It was efficacious, what they did. Was it legitimate? I'm not so sure. And this was my thesis. I said, the basic structure doctrine, which everybody now sees as the holy grail of constitutional law, has outlived its period. It was efficacious at the time it was conceived of and brought into existence. But it may not be legitimate because it does not align itself with the written text of the Constitution. So if you ask me on constitutional morality, it is the doctrine was brought in because of popular morality. People wanted an erring or an over-ambitious executive not to run amok, and therefore supported the judiciary in this whole venture. Popular morality. Constitutional morality, you're doing something which the Constitution says you can't. How can that be constitutional morality? so that's the conundrum. So that's one where constitutional morality and popular morality were slightly not with each other, aligned to each other. The second case is Navtej Singh Johar. Most of you might have heard it. This is the famous decriminalization of homosexuality. We had the section 377 of the Indian Penal Code, which criminalized homosexuality by calling it sex against the order of nature. Now, although in the 1950s up to probably the 1980s and 90s, nobody had a quarrel, majority were of the view that this is against the order of nature. But as I said, changes in society, changes in societal behavior, changes in ideas, you have different generations coming in. Sexual orientation became a new concept that you have to deal with. Now, when homosexuality was found to be a way of life for many people, they had a problem living in society because they were shunned, they were spurned by the majority. Now, our Constitution grants fundamental rights to every citizen. Fundamental rights are individual rights. And as I said earlier, the Constitution is anti-majoritarian in that sense. If you need to protect an individual right and it's a constitutional guarantee, then even if the whole of the nation stands against it, as judges, we have to uphold that. We have to uphold the individual right. We may go against the majority view. And that's why no judge of a constitutional court in our country can be popular. Right? It's an anathema under the Constitution. If you become a popular judge and you're towing the line with the majority and taking away rights of individuals, then you're not only are you not a popular judge, you're not a judge under a constitutional scheme. So this is where the real challenge was. 377 at that point in time is vintage Indian Penal Code. It was basically given to us by the British, who themselves decided not to have a penal code in England. So this was Macaulay giving us an Indian Penal Code when the British don't have a penal code for themselves. And he had these Victorian concepts inbuilt into this. Our laws of privacy, our laws of dignity, etc. started developing. And as we progressed in society with these new ideas, we started recognizing a dignity in individuals. The right to choose your sexual behavior, sexual autonomy, bodily autonomy. And at that stage, we started revisiting these laws. Now look at the trajectory that took. The Delhi High Court in Nas Foundation said that the provisions of the IPC which talk about homosexuality being criminalized are bad they offend against the principles of the Constitution, especially dignity of an individual, and therefore they must be struck down. And they said 377 is unconstitutional. It went up to the Supreme Court, the Delhi High Court judgment, and the Supreme Court said it's not for the judiciary to determine what behavior must prevail in society. That's a legislative exercise. And therefore it can't be for the judiciary to make a new law. Only the parliament or the legislature concerned can make a new law. And they actually overruled NAS Foundation. As luck would have it, 2017 you had Puttaswamy recognizing 9 judges recognizing the principles of privacy as an integral aspect of Article 21, which is your right to life and personal liberty. So now we've got armed ourselves with this right to privacy. And when you recognize a right to privacy, which includes a right of choice, a right to be left alone, a right to dignity, a right of bodily autonomy, then obviously you could not have something like 377 staring you in your face. So then came the Navdeep Johar's case. This time around, the Supreme Court said no. Section 377 has to be seen as unconstitutional because our Constitution now recognizes privacy, and therefore 377 is against the constitutional provision, and therefore it goes. So that again was one where constitutional morality prevailed over popular morality. Not that these people were welcomed in society even after that. Even now we have pockets where people are discriminated based on their orientation. And then the last case which I wanted to say was Indian young lawyers, your famous Shabarimala temple entry. You all know the facts too well. But the court in Shabarimala ultimately said that the ban was discriminatory towards women and violative of the freedom of religion. What is wrong in that declaration? They said the Supreme Court said very clearly, with the exception of one judge who happened to be a woman, they said that the ban of entry of women into the Shabarimala shrine was discriminatory towards women. If you look at constitutional morality, it's gender discrimination and violation of the freedom of religion. What if a woman actually wants to go to Shabarimala? We have freedom of thought, expression, belief, faith, worship. Would this not come under that? So constitutional morality violated. This is what the Supreme Court said, the majority judge. And this is where it gets interesting as far as Kerala is concerned. And I use this example of Kerala. We have many women here. When it comes to empowerment, women empowerment, in Kerala, we've always been in the forefront. In the public front, in the public sphere. Why is that? From the time when we recognized our state, after the State's Reorganization Act, whenever there has been a situation where in society you have faced caste oppression, social oppression of any sort, just as men came up fighting such oppression, women also flocked in great numbers. Dealing with social ostracization or dealing with social oppression included dealing with certain problems of women empowerment as well. Gender discrimination was also part of the social oppression that we had. So when you had, it is basically an intersectionality. When you had people being prevented from entering into temples, that was something that affected both men and women. And while you opposed it, the general feeling was that you were opposed to discrimination of any sort. And both men and women were equally involved, and therefore they were seen in the limelight. When it came to opportunities in public employment, we have ample opportunities for women in our state. Again, in the public sphere. Shabarimala judgment brought in a twist. The greatest opponents for the judgment of the Supreme Court were women. What does it tell you about the gender or the women's empowerment in the private sphere? We suddenly find that when it comes to the empowerment of women in personal spaces, within their homes, in private spheres, when it comes to religion, matters of religion, suddenly there's no empowerment. We're sliding back. Why? I gave this example, I cited this example in the Women's Club just 2 weeks ago. They called me for some misguided person invited me to talk about women empowerment, and I told them this. And I said, if you need to make a change in the private sphere, it needs to start at home. You need to educate your men in your family about women empowerment. Stop taking it to the streets. Start from your homes. Because unless you do that, unless you sensitize men in your homes to the needs of women and to the differences that women have, you're not going to get women empowerment or gender equality within your private spaces. I also told them not to tell their husbands that I said that. But it is a reality. And Shabarimala case showed us that reality in Kerala. So now we are talking about constitutional morality. If you look in terms of constitutional morality, Shabarimala judgment is right. But what about popular morality? Can you say that in the private spaces occupied by women in Kerala, popular morality aligns with constitutional morality? I don't think so. So these are I've chosen just those 3 cases because it brings out that stark contrast. What do we do what is the role of the state, the public officials, checks and balances, role of citizens? Essentially what we're talking when we're talking about constitutional morality is that nobody is exempted from the requirement of a commitment to constitutional principles. The state has to abide by it, the citizen has to abide by it. You need to participate in governance. A right to vote is not, everybody, you get those advertisements coming in every time there's an election of the importance of the right to vote. Why aren't we thinking of it even otherwise? So you are being governed. I mean, what difference does it make whether it's an Englishman or an Indian? You're being governed. Your rights, privileges, everything has to be determined by you. And therefore, it's central to the principle of constitutional morality that you participate actively in governance. What are the challenges today that we face? First and foremost, majoritarianism. Majoritarianism is the greatest threat to the continuance of constitutional morality. I gave you the examples of anti-LGBTQ movements, the gender biases that affect our society, political interference with the functioning of other institutions, separation of powers completely given a go by. If you start interfering in every institution, if politicians start interfering in every functioning, whether it is of the independent institutions like the Election Commission, or even the Comptroller or Auditor General, or the judiciary, where is the principles of constitutional morality? Talk about the judiciary itself. Every time we embark upon judicial activism, hyperactivism, it's an affront to the principles of constitutional morality. I have no difficulty saying that. Everybody has to know their limits. We can't go beyond a particular point. We've started reading into the silences of the Constitution. It's a famous interpretative tool these days. When the courts start reading into the silences of the Constitution. Whoever gave the authority to courts to start reading into silences of the Constitution? Silences in the Constitution were deliberate. There were times in the Constituent Assembly when they could not agree upon certain things. The Uniform Civil Code is a case in point. Because they could not agree then, they left it to future parliaments to discuss, deliberate, and then come to a conclusion whether or not you needed a Uniform Civil Code. Can you imagine what will happen if If a group of 3 judges or 5 judges sit together and decide that tomorrow we should have a uniform civil code, where is the discussion, where is the deliberation? So every time we do this judicial activism and hyperactivism and start reading into the constitution, we are offending the principles of constitutional morality. And the most important, the biggest breach of constitutional morality is when you have a lack of awareness of the constitution. And that's the message I want to leave with all of you today. Unless you as citizens, you as active citizens of this country decide to live your lives under the guidance of the constitutional principles, the biggest breach of constitutional morality is going to be committed by we, the people of India. Thank you.
Thank you so much, Dr. Justice Jayasankaran Nambiar. I think we've had one of the longest speeches in our weekly meeting. And I mean, there's no reason for you to feel sorry about it, but then I think that is the way in which a constitution can be explained, at least in the most simple manner, and we thank you very much for it. Due to paucity of time, can we avoid the questions? And shall we go?
One question, can I ask?
Oh my God. Okay. Maybe we will just have. Okay, we will restrict it to 3 questions, and I hope it's okay for you, sir. Yeah, fine. Okay then. Yes, it will be in line with the constitutional morality. Yeah, it is in line. Yes.
Yes, sir. My name is Suresh Kumar. Professionally, I'm not in the judiciary, I'm engineering. My question is about, in fact, because of that, I take the late Justice A.K, who said about the corruption in the judiciary. He said that corruption in the judiciary, it has creeped into judiciary also. And now what happened in Delhi recently with the judges' house, I remember all those things. So how this is going to happen? And again, certain cases are being postponed. The politicians involved cases are being postponed indefinitely. How this is happening?
Let me try and answer this in a simple way. First and foremost, I think most of the things that we read in the media about corruption are without understanding what actually happened. And which is not surprising, because as I say, in this world there is no such thing as an absolute truth. Everything that you hear is an opinion. Everything that you see is a perspective. It's either your perspective or my perspective. Now, there is a forum where these perspectives come to clash, and you have an umpire, neutral umpire, who is supposed to say, based on the evidence that is gathered, which is the correct perspective under the circumstances. So, when somebody sees piles of cash burning in somebody's backyard, you could simply say that somebody's planted it there and it is burnt. Or it could actually be why somebody would stock piles of money in one's backyard, I do not know. But the fact that it is unusual makes you doubt what the real story is. So I would have thought that the better course would have been to wait till an investigation is done by whoever has to do that investigation and come to a conclusion as to what actually happened, before you start drawing further inferences with regard to corruption, etc. The judge that you're talking about is one of the finest judges in the country in terms of merit, in terms of intellect. You have his judgments in the public domain, you can read this. He's a person with a stellar record in terms of intellect and his erudition. He's completed about 13 years in service. 11 years in service, and he's got probably another 5 years to go. to retire as a High Court judge. Based on seniority alone, and but for this incident, this would have been a person who you could see as a future Chief Justice of India. Now, if this isolated instance is going to put paid to all that and demolish his reputation and his career, so be it. I mean, if that's what majoritarian tendencies tend to do. But my plea to all of you would be, not only for this judge, but any such thing, wait. You know, not everything has to be like Kentucky Fried Chicken, where you get it immediately off the shelf, or a cold coffee or an instant coffee. Everything need not be, realized soon. Give it time. This is what, happens most of the time. Give it time. And understand what the facts are. Because the facts never emerge instantly. There's always, it's not a given. So my thing is, I'm very suspicious when it comes to people readily inferring corruption in everything that they see. And what is corruption? What is corruption? Corruption can be anything. I mean, it can be nepotism, it can be bribery, it can be things. But again, it's always your perspective. Please understand that in society there is always another perspective. Just as you say that there is a glass which is half full, it's also half empty. So there's always another perspective. And we need to understand that when it comes to, and it's important, you look at any field, all the knowledge, there are many women here, the data bias that they have gone through in society over the years, our language is built on that data bias. You use language which is totally loaded in favor of the male of the species. And examples are galore. Only because we have this perspective which is influenced by our thinking. And it need not be the actual truth. So always, when you start reading newspapers, they offer a perspective of the person. What does an archaeologist do when he's digging for artifacts? He finds copper vessels because that's what he's looking for. He finds terracotta structures because that's what he's looking for. Nobody's examining the soil. There's a lot of clues in the soil which you can trace back to history, but nobody's looking at that. So every effort of a human being in search of knowledge is basically a progressive elimination of ignorance. And that progressive elimination of ignorance happens because of the perspective of that particular person who is in pursuit of knowledge. And your perspective need not be aligned with mine. Even in a court, and this is why, whenever I get this opportunity, I'm sorry, I'm just taking 2 minutes more. Whenever I get this opportunity, I try to educate, people. Because everybody says, look at this typical crime investigation in our country. You find somebody being arrested. There's a crime reported on day 1. It's a very brutal murder happened in your neighborhood. 3 days later, there's a person arrested. So you're now putting the murder with the person you see in the newspaper as arrested. Now we have videos following the person and the policeman when he's taken to the scene of crime and thereafter to various other places where he's supposed to have hidden the murder weapon. And he goes there, he picks up the murder weapon, hands it over to the police. That's captured on video. As far as you and I are concerned, just these 3 visuals is enough to hang him. Right? Because what do you need? You've got the body, you've got the crime, you've got the blood in the crime scene, you've got the person who's taking up a knife and giving it to the police. It's a cast iron case. No. Because when it comes to a court of law, what is argued before a court by the prosecution is their version of what happened. They don't say that this man was murdered in such a way. They may find all this. You can have 16 different stories of how this happened. Because nobody is there to tell you how it happened. You're only seeing things and making a story out of it. Now, the catch is this. the prosecution makes out a story based on its interpretation of the evidence. The test in any court is for the court to now see whether the prosecution can walk the talk, can have produce the evidence to justify their story. We are not looking for the truth in the court. We don't know the truth. Nobody does. The truth is not there. We are only saying whether or not the prosecution has established its story by adducing evidence. Now, in that scene which you just saw, when a person goes and finds a weapon and says it, before that he would have been, third degree method, and he would be going to the place where he'll not only a knife, he'll dig out a spade also if you ask. Suppose this is given to him and the evidence comes. Whatever whatever confession he gives in police custody is not admissible in evidence. You can't produce that in court. So what can you produce under the Evidence Act? Only that portion of a statement of a victim, of an accused, that leads to the discovery of a new fact is admissible. What is the new fact here? Not the knife. The knife was discovered ages ago by earlier civilizations. What is the new fact is the knowledge that this accused has of the concealment of the knife there. That's the new fact in evidence. Only that portion, which is, if you take me to the place, I will show you where I hid the knife. That statement of his is recorded in evidence. That is admissible in evidence. And now, if he says, if you take me to the place, I will show you the knife with which I killed him, that portion is not admissible in evidence. Because that is an incriminatory statement which you give to the police. Right? So, I can use as evidence only a statement which says, if you take me there, I will show you the place where I hid a knife. A knife, not the knife. Now you tell me with this evidence, what am I going to do? I still have to prove. I still have to get proof or find proof that this was the knife that actually had killed the person. So now I'm looking for blood stains. Match it with the blood in the crime scene. If that's a match, okay, that's another loop. Link in the chain. I have to now prove that this man only showed me the knife. There's nothing to show that he was there at the crime scene. So now I have to find proof to show that he was there. Evidence of people who were in the locality. At 4:30 that evening, I saw him come there for a bath in a tank nearby. So timing, 4:30. The estimated time of murder is about 7:30. 4:30 he was in a tank near the neighborhood, so he's in that vicinity. Then there is in his statement, he says, confession statement which can't be used. There are packets, cigarette packets. Did he go to a shop to get cigarettes? All this forms part of the inquiry. Somebody must have seen him near a cigarette shop. That person's evidence is taken. It's a nightmare. And we have chosen a standard of proof for criminal matters which is very high, because the principle which is followed in civilized countries that no innocent man shall be punished. Even if 100 guilty go free, an innocent should not be punished. And therefore a standard of proof is beyond reasonable doubt. Beyond reasonable doubt is a standard which you can afford to have in a country which has the necessary infrastructure, the necessary equipment which will help in collecting evidence. Not in a country like ours. Have you seen the forensic laboratories in the country? Have you seen the manner in which they collect evidence? When you get into a crime scene, the allegation must be that somebody came in a car. These fellows were traveling in a car. The car is found. First comes the police dog. It gets into the car. So now when the forensic people come, they're going to find dog hair. apart from various other kinds of errors in the car. So, see, tampering of evidence. There was one case which we got. Nowadays they, video the entire crime scene, and they produce it along with when we're hearing appeals. So we put it up and we asked them to play the crime scene on the video. And that's because we get a better picture, because reading a mahasar prepared by a policeman, nightmare. Tekkumari, 3 meter, there'll always be a telephone post or an electric post. Electric post in 3 meter mari, അവിടെ ഒരു ചെറിയ ഒരു കടവുണ്ട്. ആ കടവിന്റെ ഇപ്പുറത്ത് തെക്കുമാറി വടക്കുമാറി. First of all, you're getting this തെക്ക് വടക്ക് itself is now you're looking like that, where is it? So the safer thing is, you ask for a sketch, and that will give you some idea. And then if you see this on video, now you're better. Horror of horrors, the video when I was seeing it, there's a tape which says do not, the police lines they put up. There's a tape. Behind that tape and right in the middle of the crime scene are 3 MLAs with their entire followers. I said, what on earth is this? And this is even before the forensics come. Frankly, we're a circus. So, back to your point, please don't draw inferences. Because if we had the ability to do that, there would not be so many cases in our country.
So thank you very much. That is one point which you said about the village officers. Give them a constitution, let them read. That's a very appreciable, because we go to village officers, so Bhumi Tarammak, etc. 3 years, it is there. We don't know what's happening.
Thank you. Srini, please.
Sir, you mentioned during your speech about the Keshavanamantavadi case, which happened to be your thesis also, which mentions about the inviolability of the basic structure of the constitution, say secularism, parliamentary democracy. Exactly 50 years after the judgment came, in 2023, a nominated member of the Rajya Sabha, who also happens to be the former Chief Justice of India, in his maiden speech said, the concept of the basic structure of the constitution is a debatable concept. He said, I don't want to say anything more about that. In the 2024 election campaign across, in the public discourse, it came up many times that a government which can come to power with a brute majority can alter the basic structure of the constitution. What is your view?
That may be wrong, because today, as the basic structure doctrine stands, no parliament can amend the constitution which in a manner which takes away or destroys the basic structure. Now the best part of the Keshavananda judgment, or probably the worst part of it, is that the judgment does not actually say what is the basic structure. The judgment does not even say what are the basic features of the constitution from which the basic structure is constructed. So today, on a case-to-case basis, it is for the judiciary to say whether a particular feature is a basic feature of the constitution. Now, if you ask me, I know I'm from the judiciary and it may be all flattering for me to accept the basic structure, but my own view is that there is an inherent danger in that, because under a constitution and constitutional morality principles dictate that the power should not be concentrated in any one authority or any one branch. And judiciary is no exception to that. So if we are the ones who are now going to be in a position to say when and the manner in which a constitution should be amended, I don't think that's legitimate. Because at the end of the day, when it comes to matters of governance, we are still a democracy, and in a democracy, it's the people's representatives that must make the law. So that worries me. That's an aspect of basic structure, and this, I think, is what the debate was all about.
That's the last question.
Justice Jayasankaran, this is regarding the center-state relationship, which I think should have been enforced more strictly. Because the way things are happening, there's encroachment, and basically, as a citizen of India, I think the state government matters more to people like us than the central government. Central government, yes, okay, foreign affairs and army, defense, things like that. But ultimately, our day-to-day living is what matters. And I think the state government should be empowered more, which is there, provision is there in the constitution. Now these concurrent subjects are being sort of taken over by the center.
No, because you must understand that although we talk about federalism, we don't have a true federalism. Article 1 of our constitution says, India, that is Bharat, shall be a union of states. Right? It doesn't say federation. Now, the essential distinction between true federalism, which you find in countries like US, and the quasi-federalism, which you find in India, is that the residual power is always with the states in a true federalism. Because what happens in a federalism? You have independent sovereign states coming together and deciding to form a group, conceding some of its powers to the center. And the center will be a repository of the powers that are so conceded by the state. But the residual power is always with the state because it's the stronger. And the federation is basically an understanding of various states coming together as a body. Right? In India, it's just the reverse. If you read the Constituent Assembly debates on Article 1, you find that here the states were brought together under a common umbrella of the union only to hold them together. Only to hold them together and prevent them from secessionist tendencies.
Was it not voluntary?
It was voluntary, but it was done with a view to keeping them together as a union, which is why the words used are India, that is Bharat, shall be a union of states. So the concept is more on unity. The principle of fraternity, which assures the dignity of the individual, unity and integrity of the nation. So we don't have a concept of federalism as it were. So when you have, you're right that today when you're talking about the GST, for example, GST is a novel exercise, a unique exercise that we've embarked upon when it comes to a simultaneous power given to both the union and the states in the matter of a sovereign function like taxation. So you have a simultaneous levy by both the union and the states. Whereas earlier sales tax, etc. was under list 2, which was entirely with the states. So today you have cooperative federalism, is what they are saying. I mean, they call it cooperative federalism. The unique, I mean, the hilarious bit is that India started off with cooperative federalism. And then at some point in between we branched out, and it was not so cooperative anyway. Because in earlier years, you had the Congress which was ruling in almost all the states and in the center. So cooperation was more or less a given. But then you had different political parties in different states, and therefore not so cooperative. But today now you've come forced cooperative federalism because of the change amendment in the constitution. So center-state relationships improving, yes, that's as much an aspect of constitutional morality as any other.
Thank you very much, Justice Nambiar, for this great evening and informative evening, I would say. Now, I would request our Joint Secretary, Anil Verma, to propose a vote of thanks.
Good evening. It's 2 hours.
I'm sorry.
No, not that. Really mean that. And I think it was nice 2 hours, and still the hall is packed. And good evening once again. And first of all, I would like to thank Dr. Lalitha Mathew for speaking about Dr. M.V. Pylee from a heart, touching moments, and really remembering Dr. Pylee. Thank you, ma'am, for the nice words and inspiration. And also, she has translated a book on Dr. Pylee, and that is available here for sale at half the cost. If anybody is interested, you can buy that. Due to lack of time, I'm not inviting her here now. And I think we all should read Constitution, right? I think you get more ideas, you get more freedom, you can move freely, you know. I think thank you, sir, for enlightening us on the Constitution, constitutional law, and the morality in very simple words. You know, like even I didn't know that. I didn't know it is very, even though it is a very vast subject. I didn't expect a person like him to sit among us and be one of us. And I didn't feel that he's a justice. I just felt that he's my friend. Thank you, sir, for being with us this evening and enlightening us to the core of that. And also thank you everyone for, especially the past president, managing committee members, and all present here. And on behalf of our token of love, I would request the president to hand over a memento to Dr. Lalitha Mathew. And for the nice evening, I again request President Bebu to hand over a memento to Justice Nambiar. Thank you, President. Thank you, A.K. and all of the members here. Thank you. Good night.
Can we rise for the national anthem, please?
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Is your not come for your son? Yeah. Your Bengal center is your travel? Yeah. Just no. That you are ready when to time. Yeah. So that will be able to go. That's right. That's
നിങ്ങളുടെ അവിടെ താമസിക്കുന്ന ഒരാളാണ് ഞങ്ങളുടെ സെക്രട്ടറി. സെക്രട്ടറി ദിലീപ് അല്ലേ? ആ, ദിലീപ്. ഹെൽത്ത് കൊള്ളാമോ? കുഴപ്പമൊന്നുമില്ല.
മീറ്റിംഗിൽ എപ്പോഴും കാണാൻ ഞങ്ങള് നായി മാത്രം